G'day everyone and welcome to Laws 11061 Contracts A, Topic 10. This week we're going to be talking about implied contractual terms, and as always my name is Anthony Marinac. Well, the end is in sight. We've got 3 weeks left in the term, and this is the final week in which we'll be talking about the interpretation of contracts. Next week we have a look specifically at the Australian consumer law, and then in the final week we talk about an amazing beast called the doctrine of privity. So at the end of this topic you should have your head well and truly around the process of contract formation, which we spoke about in the first half of the semester, and now you'll have a good basic understanding of how to interpret contracts. For those of you who are feeling a little bit underdone in terms of analysing contracts and pulling contracts apart to understand them, don't worry. The purpose of these couple of weeks worth of material has been to get your head around the basics. For the rest of this subject and for almost all of Contracts B, we're going to be practicing those skills and sharpening them, because we really can't talk about breach of contract and remedies until we have the ability to go through a contract ourselves and work out what the obligations are and how they all work. Last week we were talking about the interpretation of express terms. So these were terms which were either written down in the contract and signed, or which were brought to the notice of the contracting parties before the contract was actually formed, or which were part of an oral contract that was discussed between the parties before they started. This week we're looking at implied contractual terms. Now these are terms which were not actually written in the contract, but which for one reason or another are going to be regarded by the court as though they were written in the contract. Sound complicated? It's not really. Let's have a look at it. We're going to divide the topic up. The first thing we're going to do is divide it up into 2 types of implied terms. Those general categories of implied terms are, first, terms which are implied in order to give effect to the meanings of the parties. What do we mean by this? Well, strangely enough, when 2 parties make a contract, they don't always include everything which they need. And so sometimes it's going to be necessary to imply terms into the contract in order to make the contract say everything which the parties intended to. And there's going to be 4 types of those implied terms. Implied terms to complete the contract, terms implied from what we call a consistent course of dealings, terms implied from general custom or usage, and terms implied to give what we call business efficacy. Finally, then we'll turn to an entirely different type of implied terms, and these are terms implied by law. Now, these terms are not implied in order to give effect to the intentions of the parties. The law actually doesn't really care what the intentions of the parties were when it comes to these implied terms. The purpose of these terms is to accomplish social objectives which either the common law or the Parliament has decided are important for parties who are making contracts. So let's jump in. First thing we're going to do is divide up implied terms into those 2 categories. I've just in the little introductory spiel then gone through the basics, but it is important to have a kind of an analytical tree, if you like, which is why the flowcharts in your notes are so important. The first thing we have to ask is, are we talking about a term that is express or implied? If it's express, then we don't apply any of these rules at all. If it's an implied term, if it's something that is clearly meant by the contract, even though it's not said by the contract, we have to work out what sort of implied term it is. Implied terms giving effect to the intentions of the parties are things that they would have said if they'd thought about it. Implied terms which give effect to the law are implied terms where the law doesn't care about what the party's intentions actually was. Until you can make that distinction, I realise I've just talked about it twice in a matter of 3 minutes, but it's that important. Until you can make that distinction, there's no point going on to the rest of this week's material, because you're not going to be able to tell effectively which set of rules to apply. So let's start with terms which are implied in order to complete the contract, terms which are implied to give effect to what the intentions of the party were. Now, as I said, as I said a moment ago, there are four types. The first of these are terms implied to complete the contract. Now, some of you are probably scratching your heads at this, because when we did contract formation, we said that one of the reasons why a contract might be void is because it's incomplete, and that it's not up to the court to go around completing contracts and doing the parties' jobs for them. But on the other hand, when we looked at that topic of certainty and completeness back in topic 6, we said, well, generally speaking, the court is going to assume that the intention of the parties was to make a contract. And so if the court can, it will find a way to save the contract. And one of the ways that the court can save a contract is it can imply a term to complete the contract. I've got to tell you, this doesn't happen very often. This is not something which the court is generally going to leap to do. If you find yourself answering a problem question, or when you get to practice, if you are finding yourself looking at a contract and thinking about whether or not a term should be employed to complete the contract, you're going to have to look at it very carefully, and you're certainly going to have to go back and have a close look at York Air Conditioning and the Commonwealth, which is the topic that, the case example that I've given in the notes there. What we really had in York Air Conditioning and the Commonwealth was a court which was prepared to go a long way in order to make a contract complete. Why was the court ready to do that? Well, I suspect that you have to put York Air Conditioning and the Commonwealth in the context of the time and in the context of the moral circumstances. You see, York Air Conditioning had made a great deal of money from the Commonwealth by supporting the war effort commercially. So they were providing services which assisted the war effort, and they were making a lot of coin by doing so. When it looked like they'd actually been ripping the government off, this was certainly the Commonwealth's allegation, that carried with it not only the commercial question of whether or not the parties should have been calculating the price effectively, but there was also this moral context about whether this company had been taking advantage of the rest of the country by profiteering from the war effort. And so you can see under those circumstances why you might have had a high court that was ready to go above and beyond in order to make sure that this company met what the court might have considered to have been its obligations. So they were prepared to imply terms into the contract about how the price should be calculated. In particular, they implied in a reasonableness standard. Now, those of you who've been listening to the lectures carefully will know what I'm about to say. Because in my view, there was really no basis for the Commonwealth to imply for the High Court to imply a reasonableness standard into this contract. We have said over and over again that it is actually open to people to make an unreasonable contract if that's what they want to do. And so it shouldn't really be open to the court to turn around off the bat and say, well, even though these parties have knowingly made an unreasonable contract, we're going to turn around and imply terms into the contract to make it more reasonable. So, what you have to understand for the purpose of this court is that it is possible for the High Court to imply terms into a contract to complete it. But it's not something that's going to happen very often. It's certainly not something that's going to happen all the time. The second type of implied term is a little more common. And these are terms which are implied from a consistent course of dealings. As we've mentioned right since the very word go in this course, right since week 1 when we were talking about theories. Most contracts happen in the context of a relationship. Even business contracts quite often happen as one step in an ongoing relationship between two or more businesses. And so, if that's the case, we may be able to look, in order to complete an incomplete contract, we may be able to look beyond a single instance of transaction between the parties and put it in the context of the broader instances. So if you've got a supplier and a company and they've done business for a few years, and every time they've done business it's been with exactly the same set of conditions, and then for one reason or another someone makes an administrative error and the usual documents are not exchanged in the course of making their 18th contract, it's pretty reasonable, isn't it, for a court to say, well look, unless there was some sort of really obvious declaration of a change to the processes, we're going to assume that the intention of the parties was to maintain the same sort of rules that they'd had right the way along. And that's pretty much what happened in the case of Hayes Personnel Services and Motorline. Hayes, which is a recruiting agency, you've probably seen their advertising around the place, they placed staff in Motorline's business, temp staff. And every time they did, part of the contracting process was what's called a terms of business document. The only problem is the terms of business document was customarily given at the wrong place. It was forwarded after the contract had been formed. Now, as we know from our discussion in past weeks about the incorporation of terms by notice, terms are only incorporated if they are given to the other party before the contract is formed. And that makes sense for reasons that we've discussed. You can't really make a contract with someone and then subsequently give them a bunch of additional conditions and say, oh, by the way, I meant for these to be part of our contract and you now are bound by them. Doesn't work that way. But if you have a series of dealings, and on each occasion the dealings are accompanied by a document, which is what happened in this case. On each time that Hayes supplied staff to Motorline, they forwarded this list of conditions. Motorline really couldn't then say that by the time they got to the umpteenth transaction between themselves and Hayes, that they weren't on notice as to the terms of business which Hayes required. They couldn't really pretend any innocence at that point. And so the court was prepared to say, we're going to look at the entire course of transactions between these two parties, and we're going to say that it would have pretty clearly been understood between these two parties that the terms of business which had been imposed and accepted by Hayes on numerous occasions previously, those terms should still apply. Pretty sensible, really. There are a couple of rules, because obviously this is pretty dangerous. You wouldn't be able to say, well, we've done business once before, and these were the terms and conditions that we did the business on that time, so they apply this time. The court is not going to take that on the chin. What the court will do is look at two things. First, how long has the business relationship been in place? Obviously, the longer standing a business relationship is, the more likely the court is to say, we'll be prepared to take the consistent course of dealings and apply it to the current disputed transaction. Second is the court will consider the consistency of dealings between the parties. You see, you might have two parties who have a long ongoing commercial relationship. They've been involved with one another commercially for a long time. But there's been all sorts of different variations to the terms of their trade. If that's the case, then there isn't really a consistent course of dealings to show, is there? There's a long course of dealings, but it's a long course of inconsistent dealings. So it's not really going to meet the standard that we require in order to imply a condition into the contract. The final thing to know here is that if you're representing the party who wants to imply a term into the contract on the basis of consistent course of dealings, then you will bear the burden of proof. So whoever's trying to say this additional term should be in the contract, that party will bear the burden of proof of showing that there has been a sufficiently long and sufficiently consistent course of dealings between the parties. So that's our second way of implying terms into a contract to give effect to what we understand to be the intentions of the parties. The third way is to imply terms from general custom and usage. What we mean here is that if you have an industry where the terms of business right across the industry are really consistent, they're virtually the same, well then, even if two parties work in that industry quite regularly and they make a contract and they forget to put those regular terms in, it's quite reasonable to assume that they both understood how business works and that they both understood that any contract between them for that sort of business would have included these terms. And that's pretty much what happened in the case of British Crane Hire Corporation and Ipswich Plant Hire. These are both companies that were involved in hiring out heavy equipment for major commercial tasks. But on this in particular occasion, one of these companies needed heavy equipment for their own purposes, and they didn't have access to the exact type of heavy equipment which was required. So they hired it from another company. Now, you can pretty much see where this is going right from the start, can't you? I mean, these are both companies which were heavily involved in the business of hiring out heavy equipment. They could hardly say that they didn't understand how business was done in this particular commercial environment. They were both well and truly aware. Unfortunately, their contracting processes were pretty slack. And so it ended up coming before the court to try and decide how to fill in the gaps in the contract between the parties. And the court looked to general custom. It said, we pretty much understand how this industry works, and we think that both sides would have known. So we're prepared to fill in the gaps in the contracts by looking to the way that business is ordinarily done in this particular industry. And they're going to look at rules which you would have come across earlier in the course in the reading notes from the case of Constan and Norwich Winter Arthur. And there's 4 rules. The first is that the existence of the custom is a question of fact. Now, we talked about the distinction earlier in the semester between questions of fact and questions of law. Questions of law can be proven by relying on authorities, by relying on statutes or case law. Questions of fact cannot. They can only be proven by evidence. So whoever is intending to rely on the custom as a basis of implying something into the contract, they're going to have to stand ready to prove to the court that the particular custom exists. Now, that might be done in any number of ways. It might be done by bringing witnesses before the court who can prove it. It might be done by bringing documents before the court. It might be done by expert evidence. You'll learn all about these various options when you study the evidence subject later on in your degree. But it is a question of fact. Second, the custom must be so well known that everyone can reasonably be presumed to have imported the term. So simply having a common term, one which is usually used, one which is often used, is not enough. The custom must be so well known that everyone can reasonably be presumed to have imported that term. Now this means two things. Number one, it means that if you're seeking to rely on such a term, you're going to have pretty strong evidence that it exists. If you're seeking to resist the term, then rather than showing that the custom doesn't exist, you're probably on a safer bet by showing that even though the custom exists, it's not so well known that everyone can reasonably be presumed to have imported it. The third thing is that the implied term cannot be contrary to an express term. So in other words, if the two parties have made an express statement in their contract, in the case of the crane operation, let's say the parties made an express statement in their contract that the equipment had to be returned to a depot at the end of work every day. Well, then there would be no point in trying to imply into the contract a term based on general custom that equipment could be left on site overnight. You can't imply something from general custom which is contrary to the express statements in the contract. Finally, it's worth noting, and this will outrage some of you, that a person can be bound by a term implied from general custom even if they have no personal knowledge of the custom. So if you have someone who's engaged in this type of business for the very first time, who has no knowledge of what the general customs of the industry are, and the contract doesn't specify that those general customs apply, they can still find themselves bound anyway. If the other side can show that the general custom is in use and that it is so well known that everyone can reasonably be presumed to have imported it, and if it's not contrary to any express term, it's quite likely to be binding, even though the other party has never heard of it. I looked around for a case where that had happened, and I struggled to find one. But it is the sort of thing that is quite likely to show up on examinations and assignments. So I would probably run the highlighter over that one. Let's move on now to the next type of term, implied. This is the final type of term which we imply in order to give effect to the intentions of the parties. And these are what we call terms implied to give business efficacy to a contract. This one's really interesting. You see, in any contract, you're going to have some aspects of the contract that are not completely written out. Now, we've talked about this at other times during this lecture series. There's always going to be some level of incompleteness in a contract. Most of the time, what the parties will write down when they're actually forming the express terms of the contract is everything that they reckon is very likely to come up. Sometimes, though, they'll miss things out, and they'll miss them out because they seem to be pretty obvious. Murphy's Law says that those will be the points of dispute when the contract doesn't work as intended. And so sometimes the parties will realise that they have a dispute. They'll each run off to open up their contract. They start reading the contract and they realise, oh no, we haven't actually said anything about how to handle this situation. Well, the court can fix that. The court can imply terms into the contract in order to give it business efficacy. When we say give it business efficacy, what we mean is in order to make it work. There are 5 tests. The first is that the term must be equitable and reasonable. The court is not going to imply a term into a contract if it is inequitable or unreasonable. Now, some of you are waiting for me to do my my usual discussion about how contracts are allowed to be unreasonable, but I'm not going to do it in this case because I think in this particular instance the court is quite right. You see, whilst it is open for parties to make a contract which is inequitable and unreasonable, if the parties are going to do that, then they probably better make it explicit. It's not really reasonable to expect the court to come along and say, okay, we're going to imply new terms into this contract which the parties didn't think of putting in themselves, and we're going to imply terms in which we consider to be inequitable and unreasonable, but we think that's where the parties were going. Okay, that's a bit harsh of an expectation upon the courts. The courts will only imply terms into a contract if the courts consider that those terms are going to be equitable and reasonable. If the parties want to have inequitable or unreasonable terms in their contract, they need to put them in there themselves as express terms. The second thing is that no term will be implied if the contract is effective without it. Now what this means is that even if a contract could be improved by implying a new term, that's not going to be good enough. If the contract is effective in any way whatsoever without the implied term, then the court is not going to imply the term into the contract. Third point is that term must be so obvious that it goes without saying. This is a pretty high bar to jump, really, if you're the side who's trying to imply the term into the contract. For something to be so obvious that it goes without saying, it's going to have to be pretty jolly obvious, isn't it? If you're opposing or seeking to resist the implied term, then you can defeat it on this basis by showing that even though it might be perfectly equitable and reasonable, it's not so obvious that it goes without saying. If, for instance, there are 2 or 3 other plausible alternatives, then you can say, well, look, it's no longer so obvious that it goes without saying, it's just one of several reasonable alternatives. That argument is likely to be compelling before the court. Next is that the term must be capable of clear expression. And now that in itself probably is so obvious that it goes without saying. If the court is not going to be able to properly formulate the term in its judgment, then the court is not going to be able to express the obligations of the parties in a satisfactory way. And if that's the case, then the court's not going to be able to enforce those obligations. So if the term can't be expressed sufficiently clearly, the court's not going to imply it. Finally, the same test implies here as applied with our last set of rules. The term cannot contradict an express term of the contract. So if there are things in the contract which are actually written into the contract, you're not going to be able to overturn them by calling upon a new implied term which would give, say, greater business efficacy to the contract. So those are the bases upon which the court may consider implying terms into a contract. And essentially what we're talking about there is gap filler, logical gap filler. The court will, if we look across the whole 4 of them, what we're really saying is the court will do things to save a contract that's incomplete. But the court will only do it if the court's satisfied that it's acting in a reasonable and sensible way, and that it's also not acting in a way which is contrary to the arrangements which the parties have made themselves. So, let's move on now and look at the other type of implied duties, or the other type of implied clauses. These are things which are implied by law. And the first 2 we call the implied duty of cooperation and the implied duty of good faith. The first one is the implied duty of cooperation. And what this says is that even if you have made a contract with a party, and even if you follow the obligations of that to the letter, that might not be enough. There is a duty to have an underlying level of cooperation in order to bring about the objectives which each party had when they signed the contract. The example that I've given in the case notes there is an example where I've borrowed a book of yours, and for some reason or another we've made it a contract, and I was supposed to have the book back to you on a certain day, and in the meanwhile our relationship's broken down a bit, so I decide, okay, I'm going to return the book to you on that day, but I'm going to return it to you by leaving it in your front yard or on the front landing, even though it's pelting down with rain, and I know that by returning it in that way I'm going to ruin the book. Now, am I meeting the obligations that I had under the contract? Well, yes, absolutely. Am I responsible for the destruction of the book? Well, no, because when I placed it back in your possession, that is, when I left it at your residence, and you became responsible for it, it was still in perfectly good condition. All of the water damage happened after I'd left it at your place. You can see that in that situation I've met all of the obligations under the contract, but I've really met them in a way that the court could never regard as having been acceptable. So on that basis, the court implies a duty of cooperation which says that parties must cooperate at a basic level to bring about the intended operation of the contract. Now there's a related one which to me is actually quite a bit more interesting, called the implied duty of good faith. The implied duty of good faith is important because there's an awesome case, the Burger King and Hungry Jack's case. The implied duty of good faith says that even though in normal business operations companies are allowed to compete with one another, when they form a contract together, they have to moderate that level of competition, and they cannot use the contract as a basis to cheat the other party. Now in the Burger King and Hungry Jack's, everyone knows what Hungry Jack's is, and most people would know that Hungry Jack's is really the Australian expression of a company called Burger King, which operates in the United States. Now, what happened was that Hungry Jack's was the Australian licensee of the Burger King products and the Burger King service. And there was a massive contract between those two companies. And one of the contract's provisions required Hungry Jack's to open a certain number of new stores every year. Another provision of that same contract said when Hungry Jack's came to open a new store, it had to get the approval of Burger King for that specific store in that specific location. And that's not an unreasonable thing for Burger King to want, some level of control over where and how the products are being sold. However, what they did eventually, when there started to be disputes between Hungry Jack's and Burger King, because Burger King wanted to start trading in their own name rather than through the Hungry Jack's franchise, Burger King started refusing to approve any further expansions of the Hungry Jack's franchise. And then, having refused to approve any of those, they turned around and said, well, hang on, Hungry Jack's, you've failed to open the stores that you were supposed to open this year. And Hungry Jack's said, well, hang on, the only reason that we've failed to open those stores is because you failed to approve them. Burger King said, we don't really care. You've failed to meet the requirements of the contract, and therefore we're going to take action against you. What do you reckon? I mean, is it reasonable for one party to act in a way which utterly prevents the other party from meeting their obligations, and then to turn around and sue that party for not having met those obligations? To me, it sounds completely unreasonable, unrealistic. The court thought so too, and so the court found in favour of Hungry Jack's. Because what the court said was that Burger King had failed to meet the implied duty of good faith. So in effect, what the court was saying is that in the contract between Burger King and Hungry Jack's, there was an additional implied clause. The contract should be read as though there was a clause in it which said words to the effect of, the two companies agree to deal with one another in good faith. And so the court was prepared to say, not only are we going to read the contract as though that additional clause was in there, but we're also going to now say that in our view, Burger King, you have failed to meet that obligation, and therefore Hungry Jack's wins. Now, this need for good faith is important, but at the same time, there has to be limits around it. Because the duty of good faith, along with the duty of cooperation, is not intended to get in the way of normal business competitiveness. Businesses in a modern Western style economy are expected to compete with one another. In fact, if they don't compete with one another, the ACCC is going to come after them and hit them with billion-dollar fines. So the idea of the duty of cooperation and good faith is not to restrict business competitiveness. It is, however, to limit it within sensible, equitable, reasonable boundaries. If you make a contract with someone, then you have to deal with that contract in good faith. You have to cooperate in order to make sure that the contract is given effect. There are a bunch of other duties which are implied by the common law. Most of those are implied into specific types of contract. And I've given a bunch of dot points there and a bit more of an explanation in the notes about what some of these are. A lot of them relate to employment law, provision of a safe workplace, undertaking duties with reasonable care, not disclosing trade secrets, not poaching clients. These are things which really ought to be understood by any of the contracts in those areas anyway. In a lot of cases, these duties have now been surpassed by statute, but they still underlie the law behind the statute law. So if you had a case where for one reason or another the statute on, say, workplace health and safety didn't apply, the common law duty that employers have to provide a safe workplace is still there. It's still underlying the relationship between the employer and the employee. And so if necessary, the court can imply into a contract of employment a requirement for employers to provide a safe workplace. Next, we have duties which are implied by statute. So these are sections which are implied into every relevant contract as a result of statute. And various different statutes imply specific provisions into different types of contract. Very commonly within the financial services industry, which is very heavily regulated, you've got a bunch of different implied clauses which are read into all sorts of, not only contracts, but all sorts of other documents. And you'll learn a lot about those when you do corporations law further down the track. For our purpose, the most important set of implied duties come from the Australian consumer law. Next week, when we talk about the Australian consumer law, you'll see that the ACL provides a bunch of what we call consumer guarantees, and that these are written in to, or implied in to every contract. And as we learned last week, not only are they implied into every contract, but they can't be overcome. You cannot exclude these by the use of an exclusion clause. Rather than trying to go through all of that material now, I'll simply say hang on until next week. But what you'll see when we look at the Australian consumer law next week is that what we're actually doing is implying a bunch of additional clauses into contracts. So that brings us to the end of topic 10. In topic 10, we've looked at these beasts called implied clauses. Implied clauses are not written. They're not even considered by the parties. But the court's ready to read a contract as though it included these implied clauses in order to make it make sense, or in order to make it meet some sort of public objective. The ones that are implied in order to make the contract make sense, we call terms implied to give effect to the intentions of the parties. And there are 4 types. Terms implied to complete the contract. You won't see too many of them. Terms implied from a consistent course of dealing. If you can show that there has been a great number of dealings between two parties and that they've been on the basis of consistent terms of business, the court's likely to presume that those terms of business will continue. Terms implied from general custom and usage. These are terms which are so common within a particular industry that everyone would assume that they were in every contract. And finally, terms implied to give business efficacy to a contract. Then we talked about terms implied by law. These are terms where the law really doesn't care what the intentions of the parties were. There's a social objective that has to be met. The two key implied terms are those of cooperation and good faith. In other words, even within a competitive commercial business environment, there's still a requirement for contracting parties to deal with one another on the basis of cooperation and good faith, at least in order to ensure that the obligations contemplated by the contract are brought about. Then we've talked about some specific contract types which imply specific terms. And we've talked about the Australian consumer law, but really only so far as to say we're going to deal with this a lot more next week. Next week we will talk about the Australian consumer law, which is a relatively new development in Australian law and a really good one as well. And then that will bring us to the point where for the final week we can deal with privity, and then Contracts A is all over. I promise there is a light at the end of the tunnel. I hope you enjoy the material for this week, and I'll see you next week to talk about the Australian consumer law. Have a great week.